This is Graham Tolkemeyer, and my case is Safford Unified School District versus Reading, and is an example of unjust search and seizure, or a violation of the Fourth Amendment. So Savannah Reading was an 8th grader attending Safford Middle School in the state of Arizona. School officials got a tip from an anonymous student saying that Savannah had in her possession ibuprofen, which is also known as Advil. If the accusation was correct, it would have been in violation of the school's substance policy. Now, off the tip, the school officials pulled the 8th grader out of class, searched her possessions, including her purse, her locker, and her backpack, all looking, once again, for Advil or ibuprofen. Now, they weren't too happy with the results that they found because they didn't find any of the contraband. So what they did is they did an old-fashioned police pat-down. They did it like that there in the picture, which also, again, they were unsatisfied with the results because they found nothing, so then they did something a little unconventional. School officials ordered her to strip to her underwear. She did. She stood there in nothing but her undergarments, but the administrators were still not convinced of her innocence. She was ordered to remove her bra, which was searched with the same results as before. Finally, the waistband of her underwear was searched, and still nothing was found. After what must have been the most shocking "what did you do in school today, honey" dinner conversations of our time, the Reading family filed a lawsuit against Safford School District. It was taken all the way to Washington and the Supreme Court. Reading argued that her Fourth Amendment rights were violated, and that the search of her clothes and her being forced to strip were unjust and unconstitutional. On the other hand, Safford Unified School Districts claimed that they had just cause to search because they claimed that in a school, all you need is reasonable suspicion, and that as a school, they had ultimate authority. And furthermore, they claimed that they should be granted immunity because in the state of Arizona, they didn't break any specific laws. Now, as the Supreme Court saw it, they saw in a 7-2 vote. The members of the Supreme Court ruled that the search of the 8th grader was unconstitutional because the search must be reasonably related to the objective of the search, and the school officials did not have enough evidence to warrant a search. Although the school administrators were granted immunity because no clear law was broken. Well, I just hope that the school administrators eventually learn their lesson. Well, that's it, and thank you for listening.